Hey, welcome back to another episode of Explore the Spectrum. I'm your host, Janetta Bryant, and today we are joined with David Slonim. Hi, David. How are you doing?
Good. Thanks for having me on.
You bet. I'm excited to chat with you and to let some of our viewers learn more about the work that you're doing in our community. As an attorney in this specialized field, so many of our parents need that help as our kids transition into adulthood. We have a lot of resources for early intervention, but we're paralyzed in fear when it comes to financial guidance because we don't want to feel like we're sitting in front of the principal, right, and telling us that we've done it wrong. And then I know that there are a number of different guardianship options, and that's a bit overwhelming. In Florida, at least, there's, 5, 6, 7, 8 different guardianship options. So tell us a little bit about what you do and what you find some of your most common conversations surround.
Sure. So typically when we work with families of special needs or developmental disability situations, then we work with families to set up a guardian advocate. Usually that's the process of having one or both parents becoming their child's guardian before they turn 18. When an individual turns 18, regardless of the disability that they may be born with, for example, then they're still to be determined an individual. And so it's really vital that parents have the guardianship in place prior to the kids turning 18. Otherwise, they may not be able to have access to their children's medical information. They may not be able to have access to creating insurance or doing other things that are necessary for the benefit of their children moving forward. That also is tied in with maybe doing a supplemental needs trust for their child, because that is going to be useful even beyond the guardianship component there.
Sure. And, when you're mentioning how doing it before they turn 18 is critical, that really is the gold nugget of this conversation. And I hope people have that takeaway. Yeah, I've spoken with a number of different parents. They say exactly at midnight, they lost access to their child's medical records, right? Like they were no longer able to log in and do this. And not only does that create a hiccup in emergency care or being able to do something in the immediate, it also creates more of a prolonged issue in the court system if you're having to go and fight for guardianship and prove that they need your help. Am I right in saying that?
It could be, yeah. So what happens sometimes is if they wait beyond a person turning 18, then they may be turning into a different kind of guardianship. That would be a kind of more full-blown guardianship versus a standard guardian advocate. So it's really important that the parents get this started when the children are about 17 and a half or so. And so that's does create a little bit of a time constraint there. And I understand certainly there's a financial component to this. One thing that parents also have to keep in mind is that when they do this sort of legal planning for their children, they have to plan for themselves as well, because there's going to be certain assets that may be left behind by the parents that then would potentially cause problems for the children that they had not intended initially. So that's all part of the overall planning that they should meet with an elder law attorney and have this kind of family kind of overseen situation.
You're so spot on, which I would imagine you are as an expert in the field. But the reality of some of these different trusts, we have this misconception in our head so often that a trust is for a family that's really wealthy and that they're leaving all of this, inheritance to someone. But a lot of times it can be the instructions of how to do something. And it can be a way to get around some of these different estate taxes and probate things that get tied up for a long period of time. And so, what are some of your words of encouragement for a family that's sitting there and starting to realize that maybe this is something that they should start investigating? Can you give for instance for us?
Sure. So many times I have people coming into my office and saying, I don't need to do estate planning because I don't have an estate, just like you said earlier. My retort to that essentially is that we don't need to do estate planning as much as we do life planning, as well as what's going to happen to your stuff when you pass away. Also, who's going to make decisions for you and your family while you're maybe incapacitated. So I generally will separate the planning into life planning and then estate planning, and that really helps drive the point home to the families that it's not just talking about this grand estate situation. It's more about what's going to happen in certain instances during their life, or sometimes beyond there. And making sure that the trust is in place, making sure the guardianship is in place, maybe a successor guardian also to be set up there. If it's called a standby guardian, then that's also part of the planning process. When we have families that have a developmentally disabled child, it's usually they have more than one child, or a situation that's going to be a little more complex. So, it's not just one size fits all situation. It's really more nuanced planning for that. And so it could use various different kind of entities as far as the legal vehicles that we would have, or tools to allow for us to plan properly for it.
Okay, so the takeaways in my mind, because really and truly this is a conversation that should last for an hour or 2 hours, and we're trying to get it all down into a bite size for folks to be able to watch and get their interest engaged. But the first takeaway is to make sure that you're working on guardianship long before they're 18. That means you have to start finding a person to talk to when they're 16 and 17 so that you can get the ball rolling by the time they're 17 and a half, right? And then the other takeaway is that estate planning and having these conversations about trust are radically important, because we're caregivers to a child that is dependent on us in a lot of different ways. We are their champion. We are the ones that are out front looking out for them in so many fashions. If we're not here, how are they being cared for? So we don't get to get off easy by saying, oh, I'm just going to leave a will. We have to do a little bit extra planning. And I appreciate that insight that you've been able to provide. If someone wants to learn more about the services you offer, how do they reach you?
Well, they can find us on the web at slonimlaw.com. They can call us. We're actually in 3 different locations in Florida right now. We're in Melbourne, which is our main office. We're in Kissimmee, and also Clearwater. Again, our phone number, our main number is 321-757-5701.
That's really helpful. I really appreciate the insight that you've provided for me and for all of our viewers. And I thank everyone else that is with us today for spending this time with us as we continue to explore the possibilities.